Hi, welcome back. Once again, we are discussing civil liberties, which is chapter 5 of the text for this course. This is our third presentation. We're going to continue talking a little bit about freedom of expression and certain kinds of expression that are not protected by the First Amendment, or at least their status is somewhat controversial. Then we're going to move on and talk about other protections guaranteed in the Bill of Rights. So obscenity and pornography, again, the federal courts have made no attempt to provide a legal criterion for defining obscenity and pornography. They really didn't start working on that until the 20th century. The Supreme Court did attempt in the 1970s. Associate Justice Potter Stewart concluded, "I can't define pornography, but I know it when I see it." The lack of clear standards has meant that almost nothing can be banned on the grounds that it constitutes obscenity or pornography. And again, the challenge is, well, what is the distinction between gratuitous displays of for example, sex and art? It's a very difficult line to draw. And the result has been that there's, a great deal out there that could be offensive to many people, but that other people appreciate as a form of artistic expression. In 1996, Congress passed the Telecommunications Act that included a ban on internet pornography, and that was struck down because it suppressed speech that the court held that adults have a constitutional right to receive. So the result is you can make pornography and you can sell it online, and if there are people to buy it, then you can make money doing it. If you look America side by side, global freedom of the press, the dark areas are areas where you actually have freedom of the press, and then there's everywhere else. And again, the lighter shades, again express this sense in which government is much more aggressive in terms of preventing people from having access to freedom of the press. And again, I mentioned this earlier in a previous presentation. Democracy really can't long sustain itself without freedom of the press, because the public has to have access to information, and without that, without truthful information, it's really hard to see how you can sustain a democracy. And at some point, again, in the least democratic places, the press is simply telling people what to think, and citizens kind of implicitly know that you develop independent ideas at your own, at your own risk. So. The Second Amendment protects the right to bear arms. What that meant, if you read the Constitution and the Second Amendment, it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I think that's a fairly vague statement, but I think that when you look at the history surrounding the Bill of Rights and the ratification debates, I think it clearly was intended to reassure the states that they could form and train militias. So again, does the state's right to raise and maintain a militia imply an untrammeled individual right to keep and bear arms? And what kind of arms? In 1939, the Supreme upheld a federal gun law, concluding the Second Amendment pertained to the preservation or efficiency of a well-regulated militia. However, in 2008, in District of Columbia versus Heller, the court reversed its previous jurisprudence. Likewise, in 2010, in McDonald versus Chicago, represented again the first new incorporation in 40 years, overturning a Chicago ordinance making it extremely difficult to own a gun within Chicago city limits. Of course, recently, the court basically held that in Bruin, the Bruin decision, Clarence Thomas writing the majority decision, that in order for a gun restriction to be constitutional, there has to be some analog from the period when the Constitution was written. I think that decision was bad. I'm just going to say that. Gun rights by states, again, these are, requirements for background checks. Oklahoma is one of many states in the South and the Midwest and the Mountain West where there are virtually no background checks at unlicensed gun sellers. Should all states be required to perform background checks? Why or why not? I think one reason that you might want to consider is, again, that if you literally have no background checks, then people with mental problems, including people who might be suicidal, can find it very easy to get access to a gun, and that leads to lots and lots of problems. There is a reason why the United States suffers the single most amount, dramatically more gun-related violence than any other country in the world. The rights of the criminally accused are based on due process of law. 4 of the 10 amendments in the Bill of Rights involve protections of the criminally accused. Due process of law is a bulwark against, again, the use of the law as a weapon, where people in political power use that against people threatening their power. The precise words due process of law do not appear anywhere in the Constitution and do not appear in the U.S. Jurisprudence until the Fifth Amendment, and that's where you begin seeing that phrase and that sense in which there is a process that you have to go through in order to infringe on someone's rights. The Fourth Amendment involves search and seizures. The Fourth Amendment guarantees citizens protection from unreasonable searches and seizures. The Supreme Court's decision in Mapp v. Ohio in 1961 both incorporated the Fourth Amendment to states and reinforced the exclusionary rules ban on illegally obtained evidence. In recent years, the Supreme Court has softened its stance, allowing police what are known as good faith exceptions. But the use of mandatory drug testing touches very clearly on the Fourth Amendment, and likewise there are new technologies, tracking devices and things like that, that also have clear Fourth Amendment implications. The Sixth Amendment provides a guarantee to a right to counsel, in addition to several non-controversial provisions like the right to a speedy trial and the right to confront witnesses. The right to counsel sometimes results in freeing defendants who appear to be guilty. Again, the challenge there is that you would rather several guilty people be freed than one innocent person go unjustly to jail. The Supreme Court held in Gideon versus Wainwright, 1963, that lawyers in criminal trials are necessities, not luxuries. And even as the federal courts have become more conservative, the right to legal counsel has been expanded. It's still largely ineffective, or I should say there are still problems. Many states do not adequately fund public defenders, and that creates lots and lots of problems where, again, you have overworked and in some instances incompetent public defenders having to defend people. So that's it for this presentation. When we come back, we will finish up our presentation, our discussion of civil liberties. I'll see you next time.